Hello, this is Glenn Winningham, House of Fern, and you are listening to These Changing Times Radio Network. The program is Do You Know Who You Are? I guess to start things off, tonight we're going to talk a little bit about martial law and how everything's in martial law. We'll talk about what the courts are saying, but first of all, we'll talk about my website, and that's www.sovereigntyinternational.info. That's all one word, www.sovereigntyinternational.info. I've also got some groups, if anybody wants to find out more information, some private groups, and there's also a group on These Changing Times Radio website. If you go to the front page and go to the groups tab, you'll see a bunch of groups. One of them is called sovereigntyinternational.info. I've uploaded a few documents there. There's also a couple other groups I have that are private groups. They are at Yahoo and Google, and they're both called the same thing, Administrating Your Public Servants, at Yahoo Groups and Google Groups. And you can go there and request to join. I also do private information shares on request if anybody's interested in that. And actually the presentations or the things we discuss are taken from those private information shares. I just got a document here today that somebody sent out that's got some really good information in it. So I just wanted to read a few things out of it to everybody. And this is especially relevant to in America, but actually I found that this has to do with the Uniform Commercial Code. So anyways, we'll read some of it here. It says that, here's a court case. This is Garner versus Teamsters, Chauffeurs, and Helpers Local Union. And that's found at 346 U.S. 485. That's a U.S. Supreme Court. Quote, the body of learning we call conflict of laws elsewhere is called private international law because it is applied to adjustment of private interests, while public international law is applicable to the relations between states, unquote. So, conflict of laws, that's actually talked about, go into the law dictionary, and you'll see that in there quite a bit, is also called private international law. And here's another court case. It says, quote, in the sense of public international law, the several states of the Union are neither foreign to the United States, nor are they foreign to each other. But such is not the case in the field of private international law, unquote. And that's Robinson versus Norado. That's found at 71 RI, I guess that's Rhode Island, 256. It's also found at 162 American Law Reports, 362. And there's actually some other places too. But so let's look at that one again. It says, in the sense public international law, in the sense of public international law, the several states of the Union are neither foreign to the United States nor are they foreign to each other. But such is not the case in the field of private international law. And so, and what they're saying, what they're talking about here is, see, all of the states have corporations, okay? They have municipal corporations. There's actually a case where it talks about a state within a state, a corporate state within a state. And so it's like there's at least two states everywhere you go. And you'll see it in the paperwork. There's, for example, I'm in Delaware. There's the state of Delaware in upper lowercase. There'll also be the state of Delaware in all block capital letters. And then there's Delaware State. Okay, Delaware State is we the people. The state of Delaware in upper and lowercase is a de jure corporation that is supposed to be taking care of we the people. And then the all block capital letters state of Delaware is a municipal corporation that's been bankrupt several times probably, and is now owned and operated by, bankster thieves. But so what they're saying in the sense of public international law, Okay, the states of the Union are neither foreign to the United States nor are they foreign to each other. In other words, public international law has to do with international law between the United States, between and European countries or foreign overseas, okay, or even United States and well, I don't want to use Canada or Mexico because actually I believe Canada and Mexico are both part of the United States anyways. But anyways, so and then there's private international law. They are foreign to each other, but that's because the municipal corporations are foreign to each other. They're completely separate municipal corporations, but they're all sub-corporations of the United States. Anyways, let's keep going with this. It says also the Uniform Commercial Code, by copyright owner's own admission, is private international law. Okay, and that is very important because remember, they're saying conflict of laws is called private international law, and that the states are foreign to each other under private international law. That's the U.S. Supreme Court said that. So and the Uniform Commercial Code is private international law. That's law merchant. Okay. So in essence, the reason this is, okay, and we'll start with the reason comes up here. 77 Stat 630 to 631, Public Law 88-243 in 1963, and Public Law 88-244 in 1963 introduces and makes law providing the Uniform Commercial Code as private law enacted for the Municipal District of Columbia and the United States federal government. These law actions are expressly enforced and affect on citizens of the federal government, okay? In other words, U.S. citizens. And it says in the preamble of Public Law 88-243, it says is an act to enact the Uniform Commercial Code for the District of Columbia and for other purposes, unquote. This is where the Uniform Commercial Code enters as implied law of the land, okay? But when you say law of the land, you know, law of the land references common law. Well, in the District of Columbia, it obviously doesn't mean common law. It's kind of a little bit confusing. But at any rate, it says where the Uniform Commercial Code enters as implied law of the land, okay? For the sake of simplicity, a public law, as referenced in Public Law 88-244, is private law, only meant for private corporate citizens, not we the people. And that's true. Anything they do is corporate, and we've talked about that. And here's some citations. Quote, a private law is one which is confined to particular individuals, associations, or corporations, unquote. And that's found at 50 American Jurisprudence, page 12. That's book 50, American Jurisprudence, section 12, page 28. And then here's another quote. A private law can be enforced by a court of competent jurisdiction when statutes for its enforcement are enacted. And that's found at 20 American Jurisprudence, section 33, pages 58 and 59. And then statutes creating corporations are private acts. And that's found at 20 American Jurisprudence, section 35, page 60. And then, in this connection, the Federal Reserve Act is private law. The Federal Reserve banks derive their existence and corporate power from the Federal Reserve Act, and that's actually that's a court citation from Armano versus Federal Reserve Bank, found at 468 Federal Supplements, page 674, in 1979. And so, Federal Reserve banks are private acts, and a distinction between public and private acts is not always sharply defined when published statutes are printed in their final form. And that's actually a court citation, U.S. Supreme Court again, Case versus Kelly, 133 U.S. 21, 1890. It is all private law and international law, but may be referred to as private international law. That's the Uniform Commercial Code. And it is owned by the same people that own Public Law 88-243, 1968, The UCC was written and is owned by Unidroit, UNIDROIT, and Unidroit is the Vatican. It's in the Vatican. It's actually only about 100 yards from the Holy See, and so you can go over there and see it. To properly address public law, one must understand that it is private corporate charter that owns public law, and it is all statutory. Public law was converted to public policy in 1938. All private corporations, including governments, are under public policy and are to deal only with other corporations as described herein. A private man is not affected by public law, public policy, private law, or anything else as long as private man does not harm another private man. He is not statutory, not lawful. Public means of and concerning or affecting the common unity of the people and the assemblage of the private man. Private means not available for public use, control, or participation, belonging to a particular person or persons as opposed to the public or the government. Remember, as a corporation, the government becomes no more than another corporation and not holding any official or public position. And this is a citation taken from the Federal Tax Lien Act of 1966. Quote, "The entire taxing and monetary systems are hereby placed under the Uniform Commercial Code." So, and that's the entire taxing, okay, the banks, okay, monetary system, that means all the banks, and all the taxing system are placed under the Uniform Commercial Code, and that's taken from the Federal Tax Lien Act of 1966, and the Uniform Commercial Code is owned by the Vatican. I mean, that just ties it together so well. That is just really ties it together. I'm going to be putting this stuff in my PowerPoint presentations. The U.S. pays $260,000 a year to Unidroit for the use of the copyrighted Uniform Commercial Code, and the International Registry is the private law of Unidroit. However, please be mindful that it is not until you get to Article 10, Public Law 88-243, and it says construction with other laws that you begin to see that the laws of the Republic were left in place. In Section 28, 10-104, laws repealed, and remember that in UCC 1-103.6, it clearly states that all is to be done in accordance with the common law. So remedy is available, although hidden. This is how they brought in all the uniform laws through D.C., because all the states are subdivisions and interlocking directorates. All are simply municipal corporations of Washington, D.C., and Washington, D.C. code applies if you are a corporation, and that is true. That's why if you read in their definitions, they're very carefully worded, but they include the corporate states, but they don't include the land, okay? And that's why, my documents, I always tell them, you got to make sure that you don't suggest or imply or anything that you're in some corporation, because if you're in a corporation, you are a corporation. You have to tell them that you're on the land of Texas or the land of Delaware or something like that, and that makes it known in no uncertain terms that you're not in this corporation. And obviously, I've been able to do that because they're the ones that told me that I'm listed as sovereign in their system. So, anyways, that's pretty well what we're talking about this document. I get this stuff all the time, and this has got some really great stuff in it about law merchant, and it ties it. It calls it, the U.S. Supreme Court is talking about private international law, and then it's talking about how private international law is law merchant. It's the Uniform Commercial Code, and it's owned by the Vatican, and the U.S. pays money to use it. And the entire taxing and monetary systems are hereby placed under the Uniform Commercial Code, and that's all commercial. And that's why when you get a letter from a bank or from the IRS, it's all block capital letters and a postal code or a zip code, because they can only deal in the corporation. And so the way to deal with that is no zip code, no corporation, okay, upper and lowercase. And if they send something to you, no such person at this address. That's what I sent to them. That's the last time they communicated with me after I sued them and took them to the Supreme Court. Then I went and they tried to communicate with me one more time, and I just wrote on the outside, no such person at this address, and I made a photocopy, and I sent it back to them. And then I went and took my photocopy and attached it to a criminal complaint for treason, sedition, perjury of oath, because the commissioner can't commit perjury of oath, et cetera, et cetera. And I haven't heard back from him since. And that was in 2007, I think, something like that. Yeah, it must have been 2007. So what's that, 5 years, eh? Anyways, so the point is that this ties it all together really well, and shows how it's all corporate. It's all going to the Vatican, and that's what I've been saying right from the beginning. This all comes from the Vatican, and the Vatican is the source of all of this stuff, and that's really what it comes down to. Anyways, let's go ahead and we'll get started on this martial law that also comes from the Vatican, I might add. Government is not reason, it is not eloquence, it is force. It is a dangerous servant and a terrible master, and that's a quote by George Washington, too, by the way. Almost all governments are under martial law. Almost all governments are bankrupt. It is the responsibility of we the people to keep our government under control. And that's what happens, okay? The Vatican and law merchant, Vatican, the international bankster thieves operate under law merchant, exclusively under law merchant and martial law. And so when they go bankrupt, it's automatically, it's a state of emergency. It's a rule of necessity. Remember, we talk about martial law. Martial law rule is the rule of necessity. It's the law of emergency and necessity. And it basically says that they can do anything they want. And so that's all martial law, and that comes about because of the bankruptcy. And remember, the banks are under the Uniform Commercial Code, and the Uniform Commercial Code is owned and operated by the Vatican. This is a revised RCW, a revised Code of Washington. That's Washington State. 1.16.090, Legislative Declaration for the Civil Liberties Day of Remembrance. The legislature recognizes that on February 12th or 19th, 1942, the President of the United States issued Executive Order 9066, which authorized military rule over civilian law and lives, unquote. So right there in the revised Code of Washington, it says that that if you're a corporation, you're under martial law, okay? But again, it's all voluntary. You have to understand that, and we've talked about that on numerous occasions. But the martial law is there, and you have to understand that it's there. You have to understand how it works so that you be careful and not volunteer. There's three kinds of martial law. There's full martial law proper, and martial law rule. And that's actually taken from a case. Let me find that case. I forgot to put that in here. I was going to. That's Ex parte Milligan. That's it. I knew that, but I just seemed to slip my mind there briefly. Ex parte Milligan, and I'm looking it up right now as we speak. That's at 4 Wall, page 2. That's U.S. Supreme Court. It's also 71 U.S. page 2, which is 4 Wallace, it's an old court case. It's probably back from early 1800s, or maybe even late 1700s. I want to put that in that PowerPoint presentation. But so the important thing to understand is that this is coming from the Supreme Court, and they described about martial law rule and how it works. Anyways, there's three kinds of martial law: martial law proper and martial law rule. A full martial law is when there's a declaration of martial law issued. Troops are put on the street. It's used only during wartime. It's used on a foreign country when actually invaded by a foreign power or to put down an armed rebellion. Martial law proper is the law of the armed forces. It's when a captain tells a private what to do. It's enforced by court-martials. Martial law rule is the law of necessity and emergency. That's what happens when they go bankrupt. It becomes an emergency, a national emergency, because they don't have any money, and so they have to do something. It allows the domestic use of martial law powers. It's used during peace times. And theoretically, it's only supposed to, I've seen court cases that say that it's supposed to, emergency only lasts for, at the most, a couple of years, but this has been going on for decades. Evidence of martial law rule, military script is circulating for money, quote, the action of Congress and the passage of the first Legal Tender Act was placed distinctly upon the ground of the existing imperative need of government, and the Legal Tender Clause was urged and adopted as a war measure. Well, gee, that's martial law. That's exactly what that is. So, and then we go on, quote, the forced loans of 1862 and 1863 in the form of legal tender notes were vital forces in the struggle for national supremacy. They formed a part of the public debt of the United States, unquote. And that's taken from the same court case the other quote was just taken from, and that's found at Juilliard versus Greenman, 110 U.S. 421, 1884. So it's, quote, Congress claiming its martial law power to declare war, suppress insurrections, and repel invasions, imposed martial law in the United States and never discontinued it. The result was an extension of military and municipal jurisdiction of Congress. But where's the evidence of this? Look at the 13th Amendment, the Civil Rights Acts, the legal tender laws, the 14th Amendment, et cetera, et cetera, et cetera. And that's taken from Dyett versus Turner, the non-ratification of the 14th Amendment by Judge A.H. Ellett of the Utah Supreme Court. So, quote, the 14th Amendment is an extension of the national military powers presently used in the municipal character and enforced by municipal laws, stretched far beyond their original limitations and enforced by Article I tribunals, unquote. And that's taken from Dyett versus Turner and the non-ratification of the 14th Amendment by Judge A.H. Ellett, Utah Supreme Court. So, and that's exactly what they're doing. Think about it. We just talked about it under the law merchant. It's these municipal corporations, and they're trying to enforce their municipal laws. But again, it's all voluntary, and once you understand it, and once I just sent out a email about estoppel certificates and estoppel. Maybe I'll read that because that was actually a pretty good email. Let me see if I can't find that. We'll have a little break here. Estoppel, quote, estoppel is a bar that prevents one from asserting a claim or right that contradicts what one has said or done before or what has been legally established as true, unquote. And that's Black's Law Dictionary, 8th edition, page 1662. By getting involved in their color of law, statutes, codes, rules, and regulations, we have voluntarily given them permission to enforce their codes, rules, and regulations on us. By giving them notice that a different set of facts are true, we take away that permission. Because attorneys are running these things these days, we have to make sure and create an evidence trail. And here's another citation. This is Black's Law Dictionary, 8th edition again, page 789. No, I'm good. I'm good. I'll just keep going. So anyways, collateral estoppel. This is a definition taken from Black's Law Dictionary, page 789. It's about collateral estoppel. And it says the binding effect of a judgment as to matters litigated and determined in one action on later controversies between the parties involving a different claim from that the original judgment was based. And then definition number 2 is a doctrine barring a party from relitigating an issue determined against that party in an earlier action, even if the second action differs significantly from the first one. And it's also termed issue preclusion, issue estoppel, direct estoppel, estoppel by judgment, estoppel by record, estoppel by verdict, cause of action estoppel, technical estoppel, estoppel per rem judicam, and res judicata. Okay, remember, I think we talked about res judicata. We talked about that for sure. So, anyways, collateral estoppel is something that you can do. You're preventing them from proceeding by telling them that they have no authority, that they're perjuring their oath of office, they're engaging in felonies. If they're smart, they will not respond and will remain silent. And then this is taken from Black's Law Dictionary, 8th edition again, on page 1664, estoppel by silence. Estoppel that arises when a party is under a duty to speak, but fails to do so, also termed estoppel by standing by or estoppel by inaction. Every paragraph in my documents is an estoppel certificate and designed to put them in the position of estoppel. And here's an estoppel certificate definition from Black's Law Dictionary, 8th edition, page 1665. A signed statement by a party, such as a tenant or mortgagee, certifying for another's benefit that certain facts are correct and that a lease exists, and that there are no defaults, and that rent is paid to a certain date. And so that's a estoppel certificate in the application of a landlord-tenant issue. But then there's another definition here. A party's delivery of his statement stops that party from later claiming a different set of facts, unquote. Okay? So that's essentially by us serving our document on them by registered mail, we're delivering them a statement of a set of facts. That's exactly what we're doing. We're sending them a statement of a set of facts of what the situation is, and it puts them in estoppel. A party's delivery of this statement stops that party from later claiming a different set of facts. It puts them in a position that now they cannot claim that they didn't know or that there's a different set of facts. Okay? And they have a duty to respond if it's not true. Okay? They have a duty to respond, and we're going to go through that too. If it's incorrect for some reason, then they never respond. Quote, silence can only be equated with fraud when there is a legal or moral duty to speak, or when an inquiry left unanswered would be intentionally misleading. We cannot condone this shopping conduct. It is, if that is the case, we hope our message is clear. This sort of deception will not be tolerated, and if this is routine, it should be corrected immediately, unquote. And that's U.S. versus Tweel, found at 550 Federal Report, 2nd edition, page 997. And so, if it's fraud, if you serve them with this document and they don't respond and they have a duty to, then either they're stopped or they're engaging in a felony. Quote, fraud, an intentional perversion of truth for the purpose of inducing another in reliance upon it to part with some valuable thing belonging to him or to surrender a legal right, unquote. Okay? And that's exactly what's happening, okay, is we're telling them we demand the right. You see what I'm saying? We're taking the right. And that's Black's Law Dictionary, 5th edition, page 594. When one conveys, quote, when one conveys a false impression by disclosure of some facts and the concealment of others, such concealment is in effect a false representation that what is disclosed is the whole truth, unquote. And that's State versus Coddington, and that's found at 662 Pacific Report, 2nd edition, page 155, and that's Arizona Court of Appeals. Quote, suppression of a material fact which a party is bound in good faith to disclose is equivalent to false representation. And that's Lee versus Lloyd, found at 244 Pacific Report, 2nd edition, page 356. That's Arizona again. Quote, fraud and deceit may arise from silence where there is a duty to speak the truth as well as from speaking an untruth, unquote. Morrison versus Acton, 198, Pacific Report, 2nd edition, page 590, Arizona again. So there's a bunch of court cases, anyways, that talk about fraud, and they have a duty to respond. And so when I serve them with my document, telling them that I'm the sovereign, that I'm the king, I'm one of the people, and they have no more authority over me than a Walmart rent-a-cop, if they don't respond, then they've acquiesced. Then it's the truth. And I have them in estoppel, and if they violate my rights again, then I have them in jail. And that's what happened with some people that did do this, quite frankly. Well, I don't know that they're in jail, but I certainly know that they're not in office anymore. Anyways, so the point is that you can. It's all voluntary. The set of facts, this martial law, is based on presumption, and we gave them the right to presume certain things, but we can take that right away. And by serving them with this notice, it takes that right away. It puts them in a position of estoppel, and now it's very difficult for them to proceed. And that's why they put me down as sovereign in their system, because they're telling all of their hired thugs, leave this guy alone, because if you mess with him, then your butt's going to be in jail, and because they will take care of it for me. Quote, since March 9, 1933, the United States has been in a state of declared national emergency. Under the powers delegated by these statutes, the President may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel, and in a plethora of particular ways control the lives of all American citizens. A majority of the people of the United States have lived all their lives under emergency rule. For 40 years, freedoms and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by laws brought into force by states of national emergency, unquote. And this is taken from the U.S. Senate Report number 93-549, dated November 19, 1973. Now, do you think anything has changed? Absolutely not. And remember we said martial law rule is the law of emergency, law of necessity and emergency. And here it says in the very beginning, the United States has been in a state of declared national emergency since 1933. Okay, and do you think any other country is any different? Do you think Canada is any different? They're bankrupt, so no, they're not. And the same thing with England? No, it's the same thing. Quote, war is not carried on by arms alone. It is lawful to starve the hostile belligerent, armed or unarmed, so that it leads to a speedier subjection of the enemy, unquote. And that's taken from Article 17 of the Libre Code. Quote, the exercise of martial law jurisdiction within the several states is the usurpation of the common law and subjects the sovereign body to a jurisdiction that has no right to exist within the states. Quote, if a citizen acquires the same legal status, artificial character as those protected by the amendment through the operation of some statutory law of Congress, then said citizen may be brought within the venue of the amendment as a statutory juristic person. By this means, citizens' birthrights become of no effect, and their rights are reduced to the inferior character of statutory civil rights, mere legislative privileges, unquote. And that's, both of those quotes are taken from Dyett versus Turner and the non-ratification of the 14th Amendment by Judge A.H. Ellett. Now, let's look at those again, okay? It says it's the usurpation of the common law and subjects the sovereign body to a jurisdiction that has no right to exist within the states. And it says also, if a citizen acquires the same legal status as those protected by the amendment, okay, what was that? Okay, that was slaves, right? That was slaves. So you can get that status by making application through the operation of some statutory law of Congress, right? You have to make application, like Social Security number. Read that Social Security number, or birth certificate, okay? Then said citizen may be brought within the venue of the amendment as a statutory juristic person. A juristic person is a corporation by definition, okay? And remember, we just talked about that Uniform Commercial Code, and all of that has to do with corporations only, Okay? By this means, citizens' birthrights become of no effect, and their rights are reduced to inferior character or statutory civil rights, okay? Legislative privileges, and that's exactly what happens. The Civil Rights Act is nothing more than privileges, and they can take it away anytime they feel like it. A Federal Reserve note is a banknote. A Bank of Canada note is a banknote. Banknotes are negotiable instruments. Banknotes are commercial paper. Banknotes are money substitute. Banknotes are scrip, and banknotes are not money. Evidence of martial law rule. Income tax is collected under military authority. Government seizes money without a court order. Government seizes property without a court order. Government seizes bank accounts without a court order. I mean, that happens everywhere, it seems. You know, I mean, how many? I don't even have to even talk about that. Quote, as we have said, the federal personal income tax is collected under a military venue within a martial law jurisdiction. Federal Reserve notes are military script circulated within a military venue. The problem is that people don't understand how the entire United States is covered by a military venue. Under the Social Security Act, it was brought into existence 10 federal regional areas. These 10 federal regional areas are the same as a military base. And this is taken from the non-ratification of the 14th Amendment that we talked about. Quote, it is not unconstitutional to circulate money, military script on a military base, as the base is considered to be a military venue. Military script cannot circulate in the civil jurisdiction of the several states. To get around this constitutional bar, the Congress, via the Social Security Act, created 10 military venues called federal regional areas. The problem the Congress realized, while Congress could restructure the federal government agencies into these federal regional areas, the people could not be identified to be within this military venue but by their own consent. The solution was to create another military venue which would trick the people to voluntarily accept recognition that they are within a military venue. Congress solved this problem by creating a zip code. And that's all of this is taken from this non-ratification of the 14th Amendment. And so it's all by consent. And I can't tell you how many times, you know, we've talked about this. It's all by consent. It is absolutely all by consent. Once you understand, you know, it's easy to quit consenting and to keep yourself out of their so-called contracts, but that's what you have to do. And you have to understand what's happening and don't play the game. I mean, it's just that simple. You know, and the big reason I do this, quite frankly, you know, I cannot control what, you know, the neighbor does, okay? The neighbor might want to be a slave. I have no idea. It is a free country. If you want to be a slave, you can be a slave. I cannot control the neighbor. And so, but I can control me. And so I refuse to participate. And I will tell as many people so that as many people as possible will also refuse to participate. And ultimately, hopefully, it'll all be exposed for what it is, and everybody will refuse to participate. But it's got to start somewhere, doesn't it? Anyways, to go on. This is, again, taken from the non-ratification of the 14th Amendment. Quote, the zip code divides the United States into 10 military venues called national areas. When a citizen receives mail from an agency of the federal government, such as the IRS, now remember they're talking about a U.S. citizen. When a citizen receives mail from an agency of the federal government, such as the IRS, in the return address of the federal agency is the district within the regional area the letter was sent from. And on the address of the citizen it was sent to is the national area, zip code, in which he received the correspondence from the IRS. In other words, the correspondence was sent from one federal regional area to one of the national areas. Well, it's sent from one federal regional area, a military venue, to one of the national areas, another military venue. Taxing districts are established within one of the federal regional areas, which places the collection of taxes under a martial law jurisdiction. So, again, they're talking about U.S. citizens or the corporate citizens, okay, about the fictitious entities, citizens of the federal government. Quote, it becomes essential to distinguish between what is and what is not income, according to truth and substance without regard to form. Congress cannot, by any definition it may adopt, conclude the matter, since it cannot, by legislation, alter the Constitution from which it derives its power to legislate, and which within those limitations alone, that power can be lawfully exercised. Income is derived from capital, the gain derived from capital, etc. Here we have the essential matter, not a gain accruing to capital, not growth or increment in value in the investment, but a gain, a profit, something of exchangeable value separate from capital, however invested or employed, and coming in being derived, that is received or drawn by the recipient for his separate use, benefit, and disposal. That is the income derived from property. Nothing else answers the description. And that's in Eisner versus McComber, 252 U.S. 189, U.S. Supreme Court. And this is something that's completely unprecedented, because they had bold, they had underlined, and I looked this case up in a law book at the law library, and it's in the original. It's bold and underlined. You never see that in the law book. Evidence that there's a military occupation. Military script is circulated for money. Police use the rank structure of captain, lieutenant, sergeant, military ranks. Police refer to us as civilians. Courts presume everything. Curfew is strictly under a martial law jurisdiction. Do they have a curfew? Then it's martial law. State regional areas under a metro government provide a military venue for the peace officers to enforce martial law jurisdiction. A good example of that is the New York Metro Police Department, or the Toronto Metro Police Department, or the Lethbridge Metro Police Department. You see that kind of stuff all over the place. This is a war over the intrusion of civil law upon common law. The court of Diamond v. Harris calls civil law, statutory law, superior equity. And this is, quote, "It is difficult to see how the courts of this state are to ignore the common law as a rule of decision when it is made so by statute and adopt the civil law, even though it have the merit of superior equity," unquote. And that's Diamond v. Harris, 33 Texas, page 634. And then it says, we can't even begin to count the number of times judges, lawyers, and statesmen have said there isn't any common law anymore. It's been really replaced by statutes. They would be more truthful if they said there isn't any common law anymore. It's been replaced by martial law. And how many times have you heard people say that? I've heard them say it lots of times. There is no common law anymore. Well, yes, there isn't. There is, but you just have to know how to access it. And you certainly don't want to be one of those corporate citizens. But that's exactly what happens when you have martial law. Quote, "There is no common law of the United States as contradistinguished from individual states, and courts of the United States, instead of administering common law or any particular system, conform to law of states where they are situated," unquote. And that's People versus Folsom, 1855, 5C 373. And so they're saying that the United States has no common law, but the individual states do, and the U.S. district courts will basically recognize state law, whatever the state they're in. Quote, "In the meantime, civil law is the form of law imposed in the Roman Empire, which was largely, if not wholly, governed by martial law rule. Equity has always been understood to follow the law. To have superior equity is to turn things on their head. This is exactly what happens when martial law is imposed. If equity is a law, then it follows its own course rather than following the common law, thereby destroying the common law and leaving what's called equity in its place," unquote. And that's taken from non-ratification of the 14th Amendment again. And so that's exactly what happens when they impose martial law, is it gets rid of common law, and equity normally is supposed to follow common law, but because there's no common law, then equity can literally do anything they want. And how many times do you hear some judge in some courtroom that says, "I can do anything I want in here"? I can't tell you how many times. Lots of times I've heard that. There is no Income Tax Act. There's all our martial law statutes, okay? In Canada, the British North America Act, okay? There is no British North America Act. It's a British North America bill. And there is no Income Tax Act. It's an income tax bill. There's no Customs Act. It's a customs bill. There's no Immigration Act. When there's a defect in the legislation, there's no act. And so these are all martial law statutes. There's no transportation code. It's nothing. It means absolutely nothing. Quote, an unconstitutional act is not law. It confers no rights. It imposes no duties. It affords no protection. It creates no office. It is in legal contemplation as inoperative as though it had never been passed, unquote. That's Norton v. Shelby County. That's U.S. Supreme Court, 118 U.S. 425. An absolute nullity is in civil law. It's an act that is void because it's against public policy, law, or order. The nullity is non-curable. It may be invoked by any party or by the court. And that's Black's Law Dictionary, 8th edition, page 3391. And this is what they do in Alberta, for example. In the Alberta Judicature Act, Section 15, it says, quote, in all matters in which there is any conflict or variance between the rules of equity and common law with reference to the same matter, the rules of equity prevail, unquote. And so that's essentially telling you that they can do literally anything they want, and they can. There's no common law. Martial law is really no law at all. It's a dictatorship. What is proclaiming martial law is no law at all, but merely for the sake of public safety, setting aside all law and acting under military power, a proceeding which requires to be followed by an act of indemnity when the disturbances are at an end, unquote. And that's 8 Attorney General's opinions, number 365 and 367, February 3rd, 1857. And I think that's U.S. Attorney General. And that's taken from non-ratification of the 14th Amendment again. Quote, but individuals, when acting as representatives of a collective group, cannot be said to be exercising their personal rights and duties, nor be entitled to their purely personal privileges. Rather, they assume the rights and duties and privileges of the artificial entity or association of which they are agents or officers, and they are bound by its obligations, unquote. And that's Braswell versus United States. That's 487 U.S. 99, U.S. Supreme Court. Now, that's exactly what goes on when you go into their courtroom and they read that straw man's name and you say, yes, that's me. You're saying that I want to accept responsibility for this fictitious entity because it's a commercial court. They're all commercial courts. And so when you go in there and say that's me, you just accepted responsibility, and now you get to accept the liabilities and everything else associated with it. That's exactly what's going on. And that's why they don't want to talk to me, because I put them in a position that not only are they not trying to drag me into their commercial court, they don't even want to talk to me. And I kind of like it that way. And anybody can do it. Quote, this power of admiralty jurisdiction is extensive upon land as upon water. The Constitution makes no distinction in that respect. And if the admiralty jurisdiction in matters of contract and tort, which the courts of the United States may lawfully exercise on the high seas, can be extended to the lakes under the power to regulate commerce, it can, with the same propriety and upon the same construction, be extended to contracts and torts on land when the commerce is between different states, unquote. And so that's Propeller Genesee, Chief et al. Versus Fitzhugh. And that's 12 Howard, page 443, and that's U.S. Supreme Court, 1851. Quote, and it may embrace also the vehicles and persons engaged in carrying it on. It would be in the power of Congress to confer admiralty jurisdiction upon its courts over the cars engaged in transporting passengers and merchandise from one state to another, over the persons engaged in conducting them, and deny to the parties the trial by jury, unquote. And that's the same court case, Propeller Genesee Chief et al. Versus Fitzhugh, 12 Howard, page 443. So they're talking about over the cars engaged in transportation of passengers and merchandise from one state to another. Why do you think they make you sign when you apply for a driver's license? You have to swear under penalty of perjury at the bottom of that application form that you're a U.S. citizen, because that gives them jurisdiction. Otherwise, they don't have a shred of jurisdiction. And the same thing when you go to register a vehicle. Any state, I don't care what state, they all do the same thing. You swear under penalty of perjury that you're a U.S. citizen. Quote, Now, the judicial power in cases of admiralty and maritime jurisdiction has never been supposed to extend to contracts made on land and to be executed on land, but if the power of regulating commerce can be made the foundation of jurisdiction in its courts, and a newly and extended admiralty jurisdiction beyond its heretofore known and admitted limits may be created on water with under that authority, then the same reason would justify the same exercise of power on the land. Let's see, is that a duplicate? No? No? No, it's not. But that is the same case. Propeller Genesee Chief et al. Versus Fitzhugh, 12 Howard, 443 U.S., 1851. Quote, next to revenue taxes, the south, the late extents of the jurisdiction of the Admiralty are our greatest grievance. The American courts of Admiralty seem to be forming by degrees into a system that is to overturn our Constitution and to deprive us of our best inheritance, the laws of the land. It would be thought in England a dangerous innovation if the trial of any matter on land was given to the Admiralty. Unquote. That's Jackson versus Magnolia, 20 Howard, page 296. That's U.S. Supreme Court, 1852. Now, I just wanted to go back to slide back here. It talks about and deny the parties of the trial by jury. Okay, and how many times have you gone into a traffic court and tried to argue the Constitution, and the judge would say the Constitution doesn't apply in here, and I don't want to hear another word about it. And he is 100% correct. And you don't get a trial by jury in there. It's completely Admiralty. They're all Admiralty, and there is no justice in those courts. It's all Admiralty, and you have to understand that that's what's happening. But it's easily defeated. You make it so they don't want to talk to you. In other words, you serve that judge with one of your notices, and you tell him that he's going to be perjuring his oath if he wants to think he can communicate with you, long before they ever try anything. So then what happens if you go in there? You just arrest his butt. But 9 times out of 10, they don't want to talk to you. If you do it properly, they don't want to talk to you. They don't want to see you. They know that they don't have a shred of authority. Remember, we talked about how Admiralty has to have a stipulation. There's got to be a contract. Texas Administrative Code, Section 7931, corporations. Characters of print acceptable in names. Paragraph A and B. A says entity names may consist of letters in the Roman alphabet or Arabic numerals and certain symbols capable of being reproduced in standard English typewriter or a combination thereof. And paragraph B, only uppercase or capital letters with no distinction as to typeface or font will be recognized. Why do you think they're spelling the name in all block capital letters? It's a fictitious entity. At common law, proper name is never spelled in all block capital letters. It's a corporation. This is the Canada Prize Act. The court shall, subject to this section, take cognizance of and judicially proceed upon all manner of captures, seizures, prizes, reprisals made under the authority of Her Majesty and right of Canada of all ships, aircraft, or goods, and it just goes on and on and on. And it says aircraft or goods belong to any enemy country or citizens or subjects thereof or any other persons inhabiting any of the countries. Okay, well, that's exactly what they're doing. When you get a speeding ticket in Canada, it says right at the top of that speeding ticket, it says Canada all over the top of it. And so they're going and capturing some prize. That's exactly what they're doing. And you're a person until you defeat that. This is Title 18, United States Code, Crimes and Criminal Procedure, Part 1, Chapter 1, General Provisions, Section 7, Special Maritime and Territorial Jurisdiction, United States defined. The term Special Maritime and Territorial Jurisdiction as used in this statute includes 1, the high seas and any other waters within the Admiralty and Maritime Jurisdiction of the United States and out of the jurisdiction of any particular state. and any vessel belonging in whole or in part to the United States or any citizen thereof. That means that anybody that has a car that they swore under penalty of perjury, they're a U.S. citizen, so then they put that plate on there. That means that they're a citizen of the United States, and that car is a vessel. Or to any corporation created by or under the laws of the United States or of any state, territory, district, possession thereof, when such vessel is within the Admiralty maritime jurisdiction of the United States and out of the jurisdiction of any particular state. So that's exactly what's going on. The states, when you're a U.S. citizen in Texas, then you're a foreigner, okay? And the state has every right to regulate foreigners in Texas. And the same thing in Delaware or any other state. If you're a U.S. citizen, then you're a foreigner, and you're subject to regulation. Quote, any of the following types of crimes, this is 27 Code of Federal Regulations, Section 72.11, commercial crimes. Quote, any of the following types of crimes, federal or state. And then at the very bottom it says, will be treated as if as such were a commercial crime. Okay, so that says at the very bottom about the commercial crime. Quote, any of the following types of crime, federal or state, offenses against the revenue laws, burglary, larceny, robbery, illegal sale or possession of deadly weapons, prostitution, including soliciting, procuring, pandering, white slaving, keeping house of ill fame and like fences, extortion, swindling, and confidence games, and attempting to commit or compounding any of the foregoing crimes, in addition to narcotic drugs and use of marijuana, will be treated as if such were commercial crime, unquote. So, again, who's involved in commercial crimes? Persons. So if you read those statutes, it talks about persons. All the drug crimes, all the marijuana crimes and everything, it's all about persons. Quote, the Admiralty from the highest antiquity has exercised a very extensive criminal jurisdiction, unquote. United States versus Flores, 289 U.S. 137. Quote, Admiralty courts have a jurisdiction over contracts and torts and other special cases, unquote. And that's U.S. versus Flores, 289, 137, 1933. Quote, the criminal jurisdiction of the United States is wholly statutory. Quote, the criminal jurisdiction of the United States is wholly statutory. See U.S. versus Hudson, 7 Crimes 32, and that's State versus Flores, 289 U.S. 137. Quote, it is natural to consider the vessels of a nation as parts of its territory, though at sea, as the state retains its jurisdiction over them. This is the doctrine of the law of nations, unquote, and that's State versus Flores. That's the law of the flag, okay? That's when they put that flag up there, then that ship is under the law of that flag. Well, the same thing applies when you put that plate on there. That's a plate is a flag, essentially. That's exactly what it is. Okay, well, what we're going to do is we're going to take a little break, and we'll listen to a little music, and then we'll be back in about 5 minutes.
It's been a hard day, so tired, but it won't be long till I get home. I hope she'll still be there. Can't think what I might say. Blacktop's wet from all this rain. All I know is I'm halfway home. Hope she isn't gone. So much right now I wanna do. She's the one made my dreams come true. Halfway home ain't near enough. No clothes that escape. last thing heard. Front door closed just a little too hard. Strong words not really meant, hurtful all the same. No, now I should have turned back. Never should have rolled out the drive. Right foot down just a little too hard. That's all I had to say. So much right now I wanna do. She's the one made my dreams come true. Halfway home ain't close enough. Hope I'm not too late. Halfway home ain't near enough. Don't close up the escape. Halfway home I'm nearly blind from the tears I could not find. Halfway home I'm almost there. Just again. Halfway home ain't close enough. Hope I'm not too late. Halfway home ain't near enough. Don't close up the escape. Halfway home I'm nearly blind from the tears I could not find. Halfway home I'm almost there. Just If it's in your heart to love me, let me know. If it's in your heart to leave me, darling, let me go. 'Cause I'm tired of hanging on, wondering, just wondering about tomorrow. What to say, is that heart of yours just borrowed? Wondering if you'll stay, 'cause I'm tired of being lonely. Wondering, left wondering. The nights you left me lonely, staring into empty eyes, never saying where you're going. Midnight alibis. The smile you leave behind you never seems to be the same as the one you come back home with. Was I just another game? If it's in your heart to love me, let me know. If it's in your heart to leave me, darling, let me go. 'Cause I'm tired of hanging on, wondering. 'Cause I'm tired of hanging on, wondering.
Okay, this is Glenn Winningham, House of Fern, and you're listening to These Changing Times radio station, and the program is called Do You Know Who You Are? And we're talking about Admiralty Maritime Law, and how it's basically everywhere, or almost everywhere. the results of all of that. And before we get into that, we just want to let you know that I've got a website. It's called www.sovereigntyinternational.info. There's also a group that's on These Changing Times Radio's website, and you can go there. And what happens when I get the file from this program, I'll make it into a video so that I can upload it to YouTube. And so then for those who are not able to listen in, they can listen in at a later date to the program. And so I've also got a couple of private groups at Yahoo and Google, and they're called Administrating Your Public Servants at Yahoo Groups and Google Groups. And you can go there and request to join as well. And I also do private information shares by invitation for anybody that's interested. And the material that we cover here will be, what we'll cover. It's probably a day and a half to 2 days, 8 hours a day. It's a lot of material. And it seems like I'm adding more every day, because I find court cases that talk about this stuff, and I'm able to put it all together. Anyway, so let's get moving here. We're talking about Admiralty Maritime Law. Quote, the judicial power of the United States extends to all cases enumerated in the third article of the Constitution, but to none other. It is not cognizable by the courts of the United States unless it represents a case arising under the Constitution, laws, or treaties of the Union, or is a subject of equity, admiralty, or maritime jurisdiction, unquote. And that's Baines, which is, we talked about it earlier about what the case is. Quote, it is true that the criminal jurisdiction of the United States is in general based on the territorial principle. Commerce and criminal statutes of the United States are not by implication given an extraterritorial effect. U.S. versus Bowman, and that's States versus Flores. Okay, and that's 1933. Quote, informations are filed in the Court of Exchequer for forfeiture upon seizure of property for breach of laws of revenue, impost, navigation, and trade, unquote. And that's Kent's Commentaries, lecture number 17, Admiralty and Commerce. Now, the reason I say that is that if they're filing an information, okay, by definition, it's an admiralty case. Okay, and that's the thing you have to understand, is if they're filing an information, it's by definition. I don't know how many times I've seen people that get informations filed off. Well, that's an admiralty case, okay, and they have reason to believe that you're a vessel and you're in commerce, and that's essentially what they're saying. And so you need to understand that, because the next question I'd be asking is where's your authority, and where's the contract? I want to talk about the contract here, and start bringing up those kinds of issues. If it's an information, and I've seen them file information, especially taxing authorities file informations. They all file informations, and that's all admiralty. Quote, an information is a written accusation of a crime made by a U.S. attorney, and that's in the U.S., but it's the same everywhere, okay, which permits the government to prosecute an individual without benefit of a grand jury indictment. An indictment is required in any case where a person is being charged with an infamous crime. The Supreme Court ruled in Macon versus United States that any crime for which punishment is imprisonment is an infamous crime. The use of information has a long history. For example, in the reign of King Henry VII, writes Justice Blackstone, a very oppressive use was made of them for something more than a century, so as to continually harass and shamefully enrich the crown. Also, as the court observed in People versus Sponsler, quote, the oppressive use of this mode of prosecution by information occasioned struggles to procure a declaration of its illegality, unquote. In short, prosecutions by information have long been a means of political suppression and intimidation. And so the important thing is it's all admiralty. It's all admiralty, and you have to understand that they don't have any authority, and if you bring up the right issue, like, where's the contract here? Where have I got the stipulation? I want to see this contract. The law of the flag, maritime law, the law of the nation whose flag is flown by a particular vessel where it's registered, unquote. And that's Black's Law Dictionary, 8th edition, page 2591. The right to be represented exists only in a military courtroom. That's found at 10 United States Code, section 838. Just wanted to insert something there. Quote, the accused has the right to be represented in his defense before a general or special court-martial or at an investigation under Section 832 of this title as provided in this subsection. And so if they're trying to get you to accept a lawyer, I mean, it's an admiralty court, okay? And you start bringing up that kind of stuff. Well, since when did I agree to some admiralty jurisdiction here? Under what authority? You know, I mean, you just start challenging that stuff. Where's your jurisdiction? You know, once you challenge jurisdiction, they're supposed to prove it. And, of course, they'll just try and railroad you, but you start bringing up the right stuff. But the key is to do it long before they see you, okay? And that's why they go and put people down as sovereign in their system, because if you put it down, if you go do some estoppel on them, then all of a sudden they cannot make any presumptions anymore, and they have to honor their oath of office. But until you do the estoppel, they can go ahead and make all the presumptions all day long. Quote, we hold that no person may be deprived of his liberty who has been denied the assistance of counsel as guaranteed by the Sixth Amendment. This holding is applicable in all criminal prosecutions, including prosecutions for violations of municipal ordinances. The denial of assistance of counsel will preclude the imposition of a jail sentence. In other words, what they're essentially saying is that if you have a lawyer, then they're going to put you in jail, okay? The lawyer's job is going to be to put you in jail. And actually, when we go into the stuff about the lawyers, we'll talk about that, because I can't tell you how many times the lawyer is an officer of the court. He works for the court. He doesn't work for you, okay? He's just putting on a charade is what he's doing. And so the judge can tell the lawyer what to do behind the scenes, and the lawyer has to do it because the lawyer is an officer of the court. It's a commercial court. It's the Vatican. They're in business to make money, and you happen to be the commercial transaction today. Quote, and I'm sorry, that was a case called Argersinger versus Hamlin, and that's 407 U.S. 25, U.S. Supreme Court, 1972. Quote, and the forms and modes of proceeding in causes of equity and of admiralty and maritime jurisdiction shall be according to civil law, okay? And that's Wayman versus Southard, 10 Wall 1. And so the point is that civil law is what governs equity and admiralty and all these courts, okay? Anytime you file a lawsuit, it's the rules of civil procedure. And I don't care, even the rules of criminal procedure are under the rules of civil procedure because it's all under admiralty. Quote, Brown, Volume 2, 100, lays down the rule in these terms. The general rule, however, at present is that the admiralty acts only in rem, and that no person can be subject to that jurisdiction but by his consent, expressed by his entering into a stipulation, unquote. They got to have you in a contract. You have to agree to it. And it's all based on their presumptions. Remember we talked about that with estoppel. And all you have to do is defeat their presumptions. And now all of a sudden they don't want to talk to you anymore. That's Ramsey versus Allegory, 12 Wall 611, page 409. Quote, it is well known that in civil cases, in courts of equity and admiralty, juries do not intervene, and that courts of equity use the trial by jury only in extraordinary cases to inform the conscience of the court, unquote. And that's Parsons versus Bedford, 3 Peters 433. And so what they're essentially saying is that you're not entitled to a jury trial. And if they do have a jury trial, it's just for entertainment purposes. That's all it is. It's just for a charade. And 9 times out of 10, it's certainly not a 12-man jury. It's one of these petite juries. They don't want to spend a lot of money in your trial, so they're not going to have a lot of people in there. And you got to understand, who can they subpoena to show up for this jury? Okay, it's going to be U.S. citizens. That's the only people that they can do it to. They cannot subpoena a state citizen. They don't have authority. I know people, I don't know them, I've heard of them, that have gotten off because they demanded a jury of their peers, and they couldn't produce a jury of their peers. There must be uniformity in maritime law. Quote, there must be uniformity in maritime law. The principles of maritime law are applicable to commercial law. Therefore, there must be uniformity in commercial law. Gee, that sounds like maritime law and commercial law are the same thing. Swift versus Tyson, 16 Peters 1, 1842. Quote, civil law, and Roman civil law are convertible phrases. Okay, so now the rules of civil procedure might as well say the rules of Roman procedure. That's exactly what they might as well say, meaning the same system of jurisprudence. That rule of action which every particular nation, commonwealth, or city has established particularly for itself, more properly called municipal law, and to distinguish it from the law of nature and from international law. And that's Black's Law Dictionary, 4th edition. So the rules of civil procedure might as well say it's Roman law, the rules of Roman procedure. And so, you know, that's a great idea. I never thought about that, you know. Maybe I should, I'm going to bring that up in the next, I got a case that I'm going to be involved in here pretty soon, and I'm going to bring that up and tell them that this should be the rules of Roman procedure. And then you should be some sort of Vatican priest. Oh, that's good stuff. I don't have to think about this. Anyways, but that's what's going on. This is all the Holy Roman Empire is what it is. Title 15, United States Code, Section 44, definitions. Corporation shall be deemed to include any company, trust, a so-called Massachusetts trust or association, incorporated or unincorporated, which is organized to carry on business for its own profit or that of its members, and has shares of capital or capital stock or certificates of interest, and any company, so-called Massachusetts trust or association, incorporated or unincorporated, without shares of capital or capital stock or certificates of interest, except partnerships, which is organized to carry on business for its own profit or that of its members, unquote. And that's Title 15, United States Code, Section 44. And so a cesticate trust falls really nicely into that, and that's what a U.S. citizen is, and I got a court case here recently that I come across that says it. And so, and they even admitted it when I went to the Supreme Court. They admitted it. Quote, Admiralty law, the terms of Admiralty and maritime law are virtually synonymous. Black's Law Dictionary, 6th edition, 1990. Admiralty and maritime law are synonymous. Quote, civil law, that rule of action which every particular nation, commonwealth, or city has established peculiarly for itself, more properly distinguished by the name of municipal law, unquote. The Dictionary of English Law, Sweet and Maxwell Limited, London, 1959. Well, didn't we just have a court case that said that civil law was Roman law? And so then, you know, municipal law is Roman law too. Tax, quote, tax, an impost, a tribute imposed on the subject, and excise, the tallage. In public law, taxation signifies the system for raising money for public purposes by compelling the payment by individuals of sums of money called taxes. Some general principles of taxation have been said to be: 1, the subjects of every state ought to contribute to the support of the government as nearly as possible in proportion to their respective abilities. That is, in proportion to the revenue which they respectively enjoy under the protection of the state, and the observation or neglect of this maxim consists what is called equality or inequality of taxation. And that's Smith, Wealth of Nations, Chapter 2, 5 mil, there's a bunch of abbreviations, I'm not sure what they all mean, but that's taken from the Dictionary of English Law, Sweet and Maxwell Limited, London, 1959. And so the important thing is that subjects pay taxes. not citizens, only subjects. Okay, so a U.S. citizen is, by definition, a subject. That's my point. Okay, a U.S. citizen is a subject. It would be more properly called a subject, and there's even court cases that talk about it. Quote, the United States District Court is not a true United States court established under Constitution Article 3 to administer the judicial power of the United States, but was created by virtue of the sovereign congressional faculty granted under Article 4, Section 3, by making all needful rules and regulations respecting territory belonging to the United States. And that's Balzac versus People of Puerto Rico, 258 U.S. 298. Quote, the wearing of clerical dress or of a religious habit by lay people or by members of the clergy or religious orders by whom this use is forbidden by a definitive and legally valid directive of the competent ecclesiastical authority and officially communicated to the state authority is liable to the same penalty by the state as the misuse of the military uniform, unquote. And that's found in Article 10, 1933 Concordat, which is a contract that Hitler made with the Vatican. And so the point is that the clerical dress and religious habit that the priests wear is a military uniform. And so that's more reason to say that martial law comes from the Vatican. Quote, civil law, Roman law, oh, I think I've duplicated this one. Yes, I have. So we'll delete that. Quote, when a state forms a constitution which is approved by Congress, it is stopped to deny its validity. The action of Congress cannot be inquired into, for the judicial is bound to follow the action of the political department. And that's Luther versus Borden, 48 U.S. 1, 1849. The important part of that is that that's why the U.S. Supreme Court cannot say that the 14th Amendment was not properly ratified, or the 15th Amendment or the 16th Amendment, which a lot of people know that none of those were properly ratified, or the 13th Amendment. And so, but once Congress does it, then the courts cannot dispute it. And so they say it's a political issue. Anyways, quote, process, mandates, all process of this court issues in the name of the President of the United States, unquote. And that's Rule 45.1 of the U.S. Supreme Court Rules of Procedure. Now, the significance of that is that it's all administrative. There is no judicial branch of the government, okay? That's essentially what I'm saying, okay? You basically have a military dictatorship that's coming from the White House. And he even tells the Supreme Court what to do. Quote, every taxpayer is assessed to a trust having sufficient interest in the preventing abuse of the trust to be recognized in the field of this court's prerogative jurisdiction as a relator in proceedings to set sovereign authority in motion, unquote. So, I mean, the important thing here is that it says every taxpayer is assessed to a trust. Matter of fact, I think I'll just delete the rest of it. It doesn't matter. And that's Henry Bollins, 1912, 135, Northwest Reports, page 164. Every taxpayer is assessed to a trust. So that means a U.S. citizen is assessed to a trust too, because a U.S. citizen is a taxpayer. This has been going on for centuries, if not millennia. It's the same thing that precipitated the Magna Carta. It's the same thing that precipitated the War of Independence, and it's probably responsible for countless wars and revolutions, and it's all so the Vatican can make some money. In the U.S. Declaration of Independence, it says, quote, he is affected to render military independent of and superior to the civil power. Gee, that sounds like martial law. He is combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving his assent to their acts of pretended legislation. Gee, pretended legislation sounds like non-positive law, which is color of law. Gee, that sounds like martial law. For imposing taxes on us without our consent. Gee, that sounds like martial law. For depriving us in many cases of the benefit of trial by jury. Gee, that sounds like martial law. For abolishing the free system of English laws in a neighboring province, establishing therein an arbitrary government and enlarging its boundaries so as to render it at once an example and fit instrument for introducing the same absolute rule into these colonies. Gee, that sounds like martial law. Arbitrary government sounds like martial law. Absolute rule sounds like martial law. It's a military dictatorship. He has abdicated government here by declaring us out of his protection and waging war against us. That's martial law, and that's all in the Declaration of Independence. For protecting them by a mock trial, that's more martial law, a show trial. You know, they go and make fun of show trials, like on Star Trek they say the Klingons have show trials. They have show trials here. They do it all the time. Causes and necessities for taking up arms, 1775. Statutes have been passed for extending the court jurisdiction of the courts of admiralty and vice admiralty far beyond their ancient limits, for depriving us of the accustomed and inestimable privilege of trial by jury in the cases affecting both life and property, for altering fundamentally the form of government established by charter. And gee, all that sounds like martial law. We saw the misery to which such despotism would reduce us. Despotism, gee, that sounds like a military dictatorship. The bottom line is Magna Carta says that this has been going on from the beginning of time. The Magna Carta says we will appoint as justices, constables, sheriffs, bailiffs, only such as know the law of the realm and mean to observe it well. And that means that we can presume that they know the law, either that or somebody's perjured their oath of office. They have no right to charge a fee. They charge fees for their so-called justice all the time. Magna Carta Chapter 40 says, to no one will we sell, to no one will we refuse or delay right or justice. They do it all the time. They put on a big charade. That's why we, the people, need to get our own common law juries and need to start putting them on trial ourselves. Chapter 38 of the Magna Carta, quote, no bailiff for the future shall upon his own unsupported complaint put anyone to his law without credible witnesses. That's exactly what the cops do when they stop you on the side of the road. And they're not producing any witnesses either. Chapter 29, no freeman shall be taken or imprisoned or seized or exiled or in any way destroyed, nor will we go upon him nor send upon him, except by the lawful judgment of his peers or the law of the land. The word by the law of the land, as here used, does not mean a statute passed for the purpose of working the wrong. The section was taken with some modifications from a part of the 29th chapter of the Magna Carta, which provided that no freeman should be taken or imprisoned or seized of his freehold, etc., but by the lawful judgment of his peers or the law of the land. Lord Coke, in his commentary upon this statute, says that these words by the law of the land mean by the due course and process of law, which he afterward explains to be by indictment and presentment of good and lawful men where such deeds were done in due manner or writ original of the common law. And that's Taylor versus Porter, Thor Hill, 773, 1843, New York Supreme Court. To be the statutes that would deprive a citizen of the rights of person or property without a regular trial according to the course and usage of common law would not be the law of the land. And that's Hoke versus Henderson, 15 North Carolina reports, page 15. There are certain words that you got to not be careful about using that bring you into their martial law jurisdiction. Resident. Remember, a resident is an alien. We talked about that in Color of Law. A resident is an alien. And I don't care if he's a U.S. citizen. A U.S. citizen's a resident, too. But even a U.S. citizen is an alien. They just have the right of permanent residence. Traffic, commissioner, drive. Sovereigns travel with their private property. Human, it's the Department of Human Resources. You don't want to be a human. Liberty, liberty is something you get from a ship. Sovereigns have freedom. Mail. Now, I use mail because there's statutes that work to my advantage for that. But post. Sovereigns use post. Quote, we have no more right to decline the exercise of jurisdiction which is given than to usurp that which is not given. The one or the other would be treason to the Constitution, unquote. And that's Cohens versus Virginia, 19 U.S. 264. Every nation on the planet is under martial law. Almost every nation is bankrupt. But you have to understand it's all voluntary. It's all for Ford and GM. Are you a Ford or GM employee? Even if you were, it's only when you're at work. If you're not an employee, then what's it got to do with you? If you want to be free, then we the people need to quit letting Ford and GM run the country. That's exactly what's going on. The courts have ruled that the government is not the protector of the Constitution. If the government's not the protector of the Constitution, then who is? It's up to we the people. And how do we do that? We do that by challenging what the government does through the courts. Administratively, it doesn't have to be through the courts. It can be a lot of different ways. But the bottom line is that you got to lay a foundation, you got to build a case, and that's part of this estoppel and my notices. You got to serve them with a notice and put them in their place. You got to be the king. There's such a thing as the language of sovereignty. And that's why you got to tell them. You don't sit there and go, please, sir, can I have some more? I beg your forgiveness. Well, that's not the language of sovereignty. I demand that you do this. Get off your butt and do it now. Nobody said it'd be easy, but it is possible. And what's the alternative? Do you want to be free? Is there a price to your freedom that you're not prepared to pay? Is there a price that makes your freedom too expensive? I don't know about you, but I spent tens of thousands of dollars, literally, on doing this stuff. And, I guess that's why they put me down as sovereign in their system. But, I spend more money every day. And I don't like spending all this money on it, but I like less being their slave. And that's really what it comes down to. And so I spend the money because I'm not interested in being somebody's slave. And if they're going to hurt me, Scallion, there's a guy that has these visions of the future and stuff like that, and he says that the flag in the future is going to be that yellow flag with the snake coiled on it, and it says on the bottom, it says, "Don't tread on me." And so if you think about it, that's my attitude. Is if I'm gonna hurt you, no matter what, you want to screw with me, I'm gonna hurt you, and they might be able to do something to me, but I'm gonna hurt them. There's no doubt about it. I'm gonna hurt them in ways that they can't possibly imagine, and that's the bottom line. I'm gonna hurt them, and you might as well. It's like it says. I think even in the scriptures it says that you may have power to crush his head, but he's going to have power to bruise your heel. And so I'm going to hurt you. You want to mess with me? I'm going to hurt you really bad. Now you might have your way with me. Yeah, you might. You might get away with it, but I'm going to hurt you no matter what. I'm going to hurt you. And I build a foundation, and I make sure, and that's what I tell them, quite frankly, is if you want to violate my rights, then you need to be prepared to take me over there and blow my brains out, because by the time I'm done with you, you're going to wish you did, and I'll do it all within the law. And so if you want to be a criminal, you need to be prepared to go all the way. You want to be a criminal, you be prepared to go all the way. Be a criminal all the way and blow my brains out over there, because otherwise you're going to wish you did. And that's essentially what I'm saying. And do you know who you are? And so that is the end of the PowerPoint presentation on martial law. So I think we'll do the one on money next. We talked about that a little bit in our conversation over the last little while. And so we're going to talk a little bit about money. And in this presentation, it has some S's with 2 vertical bars, which is the traditional dollar sign. Now, that actually started off being a U superimposed over an S, and that's why the 2 vertical bars. And what happened is when they went to pesos, which is the stuff that you got in your wallet these days, Federal Reserve notes, well, they're not real money, and so they had to put 1 vertical bar instead, and that means pesos. Okay, so dollar. It's the unit employed in the United States in calculating money. Money values. It is coined both in gold or silver. It is the value of 100 cents. Now, notice a dollar is coined, okay? And that's actually pursuant to the Coinage Act, but this is a definition that's taken from Black's Law Dictionary, 2nd edition. And it's important to understand that a dollar is coined, okay? There's the stuff that you call Federal Reserve notes are not dollars. Quote, dollar each to be the value of a Spanish mill dollar is the same is now current, and to contain 371 grains, 4/16 part of a grain of pure, or 416 grains of standard silver, unquote. And that's Chapter 16, Coinage Act, April 2, 1792, Section 9. So that's taken right out of the Coinage Act. And that's what a dollar is, okay? And these Federal Reserve notes are not dollars, and we're going to talk about that. So currently on the money, it says this note is legal tender for all debts, public and private. Actually, it doesn't say that. It says it said on the old ones, okay, on the U.S. Treasury notes, it said this note is legal tender for all debts, public and private, and is redeemable in lawful money at the United States Treasury at any Federal Reserve Bank. Okay, that's what it used to say on the Federal Reserve notes. Currently on the money, it says this note is legal tender for all debts, public and private. And so what is money? There's lawful money and there's legal tender, obviously, okay? And so what's the difference? What's lawful money? What's legal tender? Well, legal tender, think about it. Legal has to do with the contract. So when you tender it, if they accept it, that's the contract, because all Federal Reserve notes are voluntary. No one has to accept a Federal Reserve note. Here's a quote by Russell L. Monk, Assistant General Counsel, Department of the Treasury, February 18, 1977. Quote, Federal Reserve notes are not dollars, unquote. Quote, the term dollars likewise is incorrect, which, according to constitutional definition, are monetary units used in exchange backed by gold or silver. Our present-day fiat issues are supported by more printed paper of the same. Therefore, they're correctly termed Federal Reserve notes, not dollars, unquote. And that's Robert P. Veitchus, Handbook of Financial Math, Formula and Tables, 1979, page 420. Quote, Federal Reserve banknotes and other notes constituting a part of the common currency of the country are recognized as good tender for money unless specifically objected to, unquote. And that's McLeod versus Hoover, 1925, 159, Louisiana, 244. In other words, you do not have to accept Federal Reserve notes. Banknotes, quote, banknotes constitute a large and convenient part of the currency of our country, and by common consent serve to a great extent all the purposes of coin. In themselves, they are not money. for they are not a legal tender, and yet they are a good tender unless specifically objected to as being notes merely and not money. And that's Miller versus Race, 1 Burr 457, Bank of the United States versus Georgia, Ken Wheat 333, Handy versus, there's a whole bunch of court cases. Anyways, and then it goes on, they subserve the purpose of money in ordinary business of life by the mutual consent, express or implied, of the parties to a contract, and not by the binding force of any common usage, for the party to whom they may be tendered has an undoubted right to refuse accepting them as money. And that's Vic versus Howard, 136 Southeast 101. Somebody sent me a message. I'm just reading it. Okay. Banknotes, okay, this is talking about banknotes now, and they're, you have to accept them. You can refuse them any day of the week, and they have to pay you money. But if you tender banknotes, then it's pretty hard to demand coin. Yeah, it's pretty hard to demand coin if you tender banknotes. Quote, this is taken from Bouvier's Law Dictionary, 1856 edition. Quote, banknote contracts. A banknote resembles a common promissory note issued by a bank or corporation authorized to act as a bank. It is, in fact, a promissory note, but such notes are not, for many purposes, to be considered as mere securities for money, but are treated as money in the ordinary course and transaction of business by the general consent of mankind. Again, it's by the general consent. It's agreed to. Black's Law Dictionary, 8th edition. Banknote, a bank-issued promissory note that's payable to the bearer on demand and may circulate as money, also written banknote. So these Federal Reserve notes are not banknotes if you think about it. And we'll get into that here shortly. Money. This is Bouvier's Law Dictionary, 1856 edition. Money, gold, silver, or some other less precious metals in the course of civilization and commerce have become the common standards of value in order to avoid the delay and inconvenience of regulating their weight and quality whenever passed. The governments of the civilized world have caused them to be manufactured in certain portions and marked with a stamp which attests their value. This is called money. And that's essentially what it is, isn't it? Bouvier's Law Dictionary, 1856 edition. Black's Law Dictionary, 8th edition. Quote, real money. Money that has a metallic or other intrinsic value as distinguished from paper currency, checks, and drafts. And then definition number 2 is current cash as opposed to money on account. Money is that metal, be it gold or silver, that receives authority by the prince's impress to be current. For as wax is not a seal without a print, metal is not money without an impression, unquote. And that's Jacob A. New Law Dictionary, 1750. And that's taken from Coke's Littleton, section 207 also. Promissory note. And this is what we'll talk about here because this is Federal Reserve notes here. It's talking about Federal Reserve notes here. Promissory note, contracts, a written promise to pay a certain sum of money at a future time unconditionally. A promissory note differs from a mere acknowledgement of debt without any promise to pay, as when a debtor gives his creditor an IOU. And that's taken from Bouvier's Law Dictionary, 1856 edition. So that's what the Federal Reserve note is. It's an IOU. That's all it is. It is nothing more than an IOU. And in fact, there is no way they can ever pay those things off because the interest is never created. And so it's physically impossible to pay those things off, to ever pay those things. And they won't. They can't. It's impossible. And that's why they set up a separate corporation like the Federal Reserve, because the Federal Reserve will eventually go bankrupt, and the Treasury, it'll be the Federal Reserve that goes bankrupt. It's the limited liability. Federal Reserve Acts. This is the Gold Reserve Act of 1934, and that's found at 48 Stat 337. Quote, in Section 15, as used in this act, the term United States means the government of the United States. The term currency of the United States means currency which is legal tender in the United States and includes United States notes, Federal Reserve notes. Well, think about that. It says it defines the United States as being the government of the United States, and then it says that the term currency of the United States means currency which is legal tender in the United States, which means legal tender in the government of the United States, and includes United States notes and Federal Reserve notes. So United States notes and Federal Reserve notes are government money. They're meant for internal circulation only in the government of the United States. And Section 16, the right to alter, amend, or repeal this act is hereby expressly reserved. In other words, they cannot alter, amend it, or repeal it. Section 17, all acts or parts of acts inconsistent with any provisions of this act are hereby repealed. So they basically overrode everything else and put that as being superseding everything else. And that's the Gold Reserve Act of 1934, 48 Stat 337. Banknotes are a money substitute. Checks are a money substitute. Promissory notes are a money substitute. Quote, don't forget that the term dollar reflects a unit of silver. When the term dollar is used with respect to gold, it becomes a comparative term between the value of gold and silver, with silver being the constant and gold, in a sense, being given a respective value according to the true economic conditions. And that's non-ratification of the 14th Amendment by Judge A.H. Ella of the Utah Supreme Court. Script. Script is certificates of ownership, either absolute or conditional, of shares in a public company, corporate profits. A script certificate is an acknowledgement by the projectors of a company or the issuers of a loan that the person named therein, or more commonly the holder, remember these are bearer scripts, or more commonly the holder for the time being of the certificate, is entitled to a certain specified number of shares, debentures, bonds, etc. It is usually given in exchange for the letter of allotment and in turn is given up for the shares, debentures, bonds, which it represents. The term is also applied in the United States to warrants, like orders drawn on the municipal treasury, and to fractional paper currency issued by the United States during this period of the Civil War. And that's Black's Law Dictionary, 2nd edition, 1910. And they're talking about U.S. Treasury notes there. That's exactly what they're talking about. And so a U.S. Treasury note is a, what do they call it? A credit, bills of credit. A U.S. Treasury note is a bill of credit. It talks about that in the Constitution. It prohibits it, too. Yeah, anyways. So, script, a document that entitles a holder to receive something of value. See land script, money, a special paper money that is issued for temporary use. Black's Law Dictionary, 8th edition. Articles of Confederation, Article 4. The better to secure and perpetuate mutual friendship and intercourse among the people of the different states in this union, the free inhabitants of each of these states, paupers, vagabonds, and fugitives from justice excepted, shall be entitled to all privileges and immunities of free citizens in the several states, and the people of each state shall have free ingress and regress to and from any other state, and shall enjoy therein all the privileges, unquote. And that's Article 4, Articles of Confederation. The important part I want to point out is that you have free travel between states unless you're a pauper, vagabond, or fugitive from justice. And think about it. If all you have in your wallet is Federal Reserve notes, those are just IOUs. They are absolutely nothing. And so I remember when I used to cross the border before I found out that I was an American national, I used to have to, when I went into the travel from Canada to the U.S., and they would always ask me, do you have any money? I never realized the significance of that. I'd pull out some banknotes, and or I'd tell them, well, I got some in the bank. I got an ATM card. I'll just get it out of the bank. And you know, I mean, what business is it of theirs? Well, I guess the business was that they wanted to know if you're going to pull out a coin. And now that's what I would be pulling out is, yeah, I got more money than you got. I'll bet you don't. I bet you're bankrupt. And I got money here. This is real money. You're a vagrant. Pauper, one so poor he must be supported at the public expense. Well, think about it. If all you got is Federal Reserve notes, then you are being supported at the public expense. Bouvier's Law Dictionary, 1856 edition. Bouvier's or Black's Law Dictionary, 8th edition. Pauper, a very poor person, especially one who receives aid from charity or public funds. Title 12, United States Code, Section 411. Federal Reserve notes to be issued at the discretion of the Board of Governors of the Federal Reserve System for the purpose of making advances to the Federal Reserve banks or the Federal Reserve agents as hereinafter set forth and for no other purpose are authorized. The said notes shall be obligations of the United States and shall be redeemable by all national and member banks and Federal Reserve banks for all taxes, customs, and other public dues. They shall be redeemable in lawful money on demand at the Treasury Department of the United States in the City of Washington, District of Columbia, or any Federal Reserve Bank. Well, I've tried to get them redeemed, and they don't want to talk to me. And so that's a bunch of garbage. But at any rate, they're supposed to be redeemable. Quote, it is an established fact that the United States federal government has been dissolved by the Emergency Banking Act, March 9, 1933, 48 Stat 1, Public Law 89-719, declared by President Roosevelt being bankrupt and insolvent. House Joint Resolution 192, 73rd Congress in session June 5, 1933, Joint Resolution to suspend the gold standard and abrogate the gold clause, dissolve the sovereign authority of the United States in the official capacities of all United States governmental officers, and departments, and is further evidence that the United States federal government exists today in name only, unquote. And that's United States Congressional Record, March 17, 1993, Volume 33. Government is not reason, it is not eloquence, it is force. It is a dangerous servant and a terrible master, George Washington. The action of Congress in the passage of the first Legal Tender Act placed distinctly upon the grounds of the existing imperative need, and the Legal Tender Clause was urged and adopted as a war measure. And that's U.S. Supreme Court, Juilliard versus Greenman. And that's found at 110 U.S. 421, 1884. So the point I want to make is that it's all, again, martial law. We talked about that the last presentation. Quote, the forced loans of 1862 and 1863 in the form of legal tender notes were vital forces in the struggle for national supremacy. They form part of the debt of the United States. And again, that's again showing that it's all because of the martial law. Federal Reserve note is a bank note. A Bank of Canada note is a bank note. Bank notes are negotiable instruments. Bank notes are commercial paper. Bank notes are a money substitute. Bank notes are scrip. Bank notes are not money. Bank notes are military scrip. Bank notes are legal tender. Bank notes are forced loans. Anyone who uses them are forced to loan the government money. Bank notes are not a promissory note. They're an IOU, or at least Federal Reserve notes. It depends. It can be a promissory note, but the ones that are circulating these days are IOUs. When you pay for something with an IOU, you create a usufruct, okay, and that's a type of a trust. And if the debt of the United States was paid off, there would be no paper money in circulation. It would be physically impossible to pay it off because what would happen is all the money in circulation would be gone before the debt was paid off. And so it's physically impossible to pay it off. And when you buy stuff, it creates a trust. That's the reason. Remember, under the Uniform Commercial Code, they took over the banking system and the monetary system of the United States, and as a result, everything is in commerce. And if you're commercial, then you're a slave. But you don't have to be. It's all in, whether you consent or not. Equity. In early history of the law, the sense affixed to this word was exceedingly vague. Well, I'm not sure if I want to go through all of this. This is stuff that we covered elsewhere. Well, we can cover it. Equity in early history of the law, the sense of the affixed to this word was exceedingly vague and uncertain. This was owing in part to the fact that the chancellors of those days were either statesmen or ecclesiastics, perhaps not very scrupulous in the exercise of power. It was then asserted that equity was bounded by no certain limits or rules. It was alone controlled by conscience and natural justice. And that's Bouvier's Law Dictionary, 1856 edition. Equity is the power of the court to basically ignore the law and do the right thing. Equity, court of equity. A court of equity is one which administers justice where there are no legal rights or legal rights, but the courts of law do not afford a complete remedy, where the complainant also has an equitable right. And that's Bouvier's Law Dictionary, 1856 edition. And that's exactly right. And in fact, the bankster thieves, have an equitable interest in your home because of the mortgage. But so they have an equitable interest, but that's it. They don't have legal title. There's two kinds of title, legal title and equitable title. Equity. This is Black's Law Dictionary, 7th edition. Equity, the system of law or body of principles originating in the English Court of Chancery, superseding the common and statute law, together called the law in the narrow sense. When the two conflicting in appealing to the equity of the court, she was appealing to the king's conscience, right? So that's where they were talking previously about natural justice, because natural law is basically doing the right thing, okay? It's the law of nature. And in other words, sometimes common law doesn't really provide a very good remedy. Common law can be very severe. And so if you a lot of times, not a lot of times, but sometimes common law may not provide a very good remedy. And so people will ask the court, basically, by making equitable arguments, to bend the rules, basically. And they have that power. The problem is that under martial law, there's no common law, and so then the court can do literally whatever it wants. And that's what you see happening nowadays, where the judges will actually tell you, I can do anything I want, and where the judge will sit there and let the bankster thieves steal your house, and all that stuff. All corporations are agencies of the government. This is Bouvier's Law Dictionary, 1856 edition, definition number 7, private corporations. In the popular meaning of the term, nearly every corporation is public in as much as they are created for the public benefit. And so, they're agencies of the government. All corporations are agencies of the government. Think about it. I mean, they're the ones that are wanting tax ID numbers. They're wanting to deduct taxes. This is all because they're an agency. The dollar symbol, the S with 2 vertical bars, started out as a U superimposed over an S, and that was because of the U.S. dollar. And it was something that was recognized around the world. Eventually, it evolved to just a S with 2 vertical bars, which symbolized the U.S. dollar, which is a certain weight of gold or silver coin. That's lawful money. Because they had to differentiate between lawful money and the IOUs, Federal Reserve notes circulating for money, the dollar symbol was changed from an S with 2 vertical bars to an S with 1 vertical bar, and that's the symbol that you see these days. Now, you can actually, on a computer, the Garamond font, bigger than 14, will give you an S with 2 vertical bars. And so, but I always like to specify, that I want, matter of fact, I usually try and what I'll do is I'll say that I want pieces of silver. In other words, if I want $50,000, I want 50,000 pieces of silver, 1 troy ounce each, pieces of pure silver, 1 troy ounce each. Anyways, today the S with 1 vertical bar symbolizes many currencies, including Canada, Mexico, U.S., and many other nations. Matter of fact, there's people in Canada that call it the peso, and because it's the same symbol as the Mexican peso. And in fact, they've tried to pay taxes with pesos. They would get some Mexican pesos and pay the taxes with it. Yeah, that didn't go over too well anyways. The courts presume that dollar, the S with 1 vertical bar, when you spend money or talk about buying something or do anything, they presume that pesos are what's used, unless you specify something else. That's what they will presume, and that's what comes into the land titles presentation, because with land titles, if you specify that you paid gold or silver coin, then it becomes a deed, becomes a bill of exchange, and everything changes. And I have actually, I've got several pieces of land now that I don't pay property taxes on, and usually I don't get into a battle over it, but I actually have recently with in Arizona. It was Navajo County decided they wanted to send me a thing over property taxes, and I basically sent them back a notice, and I told them that your tax code is not positive law, therefore it's by definition colored law, and so therefore if you proceed with this, then you'll be violating my rights under the colored law, and you need to be prepared to take me out back and blow my brains out, because by the time I'm done with you, you're going to wish you did. And I haven't heard a peep from them since, and it's been over a year now. But so anyways, the important thing is that you got to educate them sometimes. It would be treason or a breach of trust. Treason is a breach of trust. It would be treason for the government to neglect to provide a way to lawfully pay for something. And so in Canada, they have a Bills of Exchange Act, and in Canada, they have gold or silver coin. It's all available. In the U.S., it does too. It's all available. All governments provide gold or silver coin, lawful money. I mean, you can buy, I think they call them sovereigns in England. And I know you can buy Krugerrands in Germany, or no, Krugerrands are in South Africa. In Germany, it's called, I'm not sure what it's called in Germany. But the point is that they all provide lawful money. There's nothing stopping you from using lawful money. Equity. Stocks are called equities because you were paid for, they were paid for with an IOU. You have an equitable interest in the corporation, but you don't own it. Because all corporations are agencies of the government. You just have an interest in it, an equitable interest. Common law has all the solutions we need. Common law is we the people. Common law is God's law as found in the Bible. Common law is 800 years of jury trial decisions. Common law is completely honest. And the sooner we get to common law, the better. Because based on what we've got right now, we just have a bunch of criminals, and we're finding out the hard way that they are criminals. In order for you to have honest de jure government, you have to have honest de jure measures. There are two kinds of title: legal title and equitable title. Yeah, why don't we go ahead and take a break, and then we'll continue on.
Early in the morning, before the sun came up, felt a night wind blowing at the crossroads in the dusk. Standing there I saw a man, bloodstains on his soul, and he gleamed his eye as cold as steel, one pocket full of gold. Say, young man, he beckons with one finger of his hand, come sit with me for just a while and I'll help you understand what it takes to play this game, one lesson yet to learn. The road from here is never clear. Beware your every turn. No mistake, I tell you true. The just man will prevail. No sacrifice is worth the price. You see, you must not fail. On down the road I've traveled far. I've lived 10 lives in one. And what I've learned I'll give to you. My playing days are done. What's it for? That's all my time. The rest I feel is up to you. Don't do all I can. Daddy turned and walked away, faded into time. So there I stood, a shaking man, not sure what I had seen. I knew the face, but I couldn't place the man that might have been. And as I walked back down the road, I looked but couldn't see. Was never there, that crossroads by the inside the storm was rising, like a tempest brewing strong. Till the waves crash over me, I knew I wasn't wrong. Up to this point I lived my life, one worry at a time. Still the echo of that word rings loudly in my mind. Set out so long ago, I did ponder what he said. I've seen this world, I've lived my life, I've walked the living dead. And now I'm sure I know that man, I see him every day. Those staring eyes, cold and still, shadow was all he said. Enough, the rest was in his eyes. For on the day the night wind came, I hadn't realized. Across the boundary set in time, I had planted just one seed and built that road across my path where the future came to me.
right, I'm back. This is Glenn Winningham, House of Fern, and you're listening to These Changing Times radio station, and this is Do You Know Who You Are? And we're talking about money, actually. We talked about martial law here earlier, and now we're talking about money. And before we get too carried away, I've got a website. It's www.sovereigntyinternational.info. I've got some groups. I got a group on These Changing Times Radio's website. If you go to the front page, there's a link to groups, and the group is called sovereigntyinternational.info. I've also got a couple private groups at Yahoo and Google. They're called Administrating Your Public Servants. And you can go there and request to join if you wish, and I've got a bunch of files and documents that I've uploaded there. Other than that, my YouTube profile, I've got about 100 YouTube videos uploaded to YouTube, and actually this program, once I get the file, I'll convert it to a video and upload it to YouTube, and the link to that will be available on the These Changing Times Radio, on the group that's on These Changing Times Radio's website. But you can also go to YouTube, and my profile is Sovereign Living. And so let's get moving here. We got about a half hour left, and so we'll wrap up this land presentation and maybe start on something else. It's hard to say. At any rate, so there's two kinds of title. This is a money presentation, I'm sorry. Anyways, there's two kinds of title. There's legal title and equitable title. Legal title is you own it, but equitable title is based on what some crook on the bench decides, basically. But there's two kinds of title. There's legal title and equitable title. And but when you pay for something with an IOU, do you really own it? And at common law, if you want to really own it, you have to really pay for it. And so if you used Bank of Canada notes or Federal Reserve notes or Bank of England notes to pay for something, then you didn't really pay for it. And because that's just an IOU, and so it's not paid for, and it creates a trust. It's a type of a trust called a usufruct, and look it up. And so what happens is that it's not really paid for, and that's why with land, that's why they charge you property taxes. That's why you don't really own it. That's why they have this feudal system in place where if you don't pay these property taxes, which are really a yearly rent, that they'll take your land from you, and they'll do what's called a unlawful detainer action. And an unlawful detainer action is one where they evict a tenant. And furthermore, when you buy the land, they ask you if you want to vest title as tenants in common or joint tenants. Well, think about it. The operative word there is tenants. We'll talk about that when we get to land a little bit more. But so the point is that if you want to really own something, then you have to really pay for it. And that's why when it comes to anything in writing, I always put down that I paid. Of course, when you're buying a vehicle, usually you're spending a heck of a pile of money and maybe even getting a loan on it, so it's impossible to do this. But if you do pay cash, then I would tell the owner that I want to, I'm gonna pay for this in silver, and we're gonna put silver down here. Now, if you want Bank of Canada notes, I don't have a problem giving you Bank of Canada notes, but I want this bill of sale to say silver coin, and that is very powerful. Because what happens then is that it's paid for. There's a guy that I met in Edmonton that what they did was there was a guy, he was telling me about a friend of his that the bankster thieves were trying to steal his car because he was behind on the payments. And and I guess the car was worth about, $16,000 or something like that, and he owed about $5,000 on it, and so had about I don't know. What they did is they did up a bill of exchange for where the guy did agree to transfer his legal and equitable title in exchange for $5,000 worth of labor. And so once they got the bill of exchange all signed and everything, then he went down to the bank and he says to the bank, he says, I got this bill of exchange on this vehicle, and you have a lien on the vehicle, and I want to know what your interest is in this vehicle. And the idea being, he figured they'd tell him that there's $5,000 owed on it or $10,000 or whatever it is, and he was going to have to cut a check to pay this interest, what their interest was in the vehicle, to get them to sign it over to him. Anyway, so he went down to the bank, and all he said was, I got this bill of exchange, and the labor's done, and I want to know what your interest is in this vehicle. And the bank said to him, they says, can you come back in half an hour? And he says, sure. And so he went down the street, had a coffee, went back in half an hour, and the bank signed the vehicle over to him. And that's the power, okay? Because when you really pay for something, you have to think of it as the matrix. If you're in corporate, okay, everything is an illusion, okay? Everything, everywhere is an illusion. But when you really pay for something, well, now all of a sudden it's not an illusion anymore. It's real, and everything changes. And this was in Canada. And that's what happened in Canada, and so it's very powerful. But again, you have to know what's going on, and a lot of their power is, remember, they went and put the banking system and the monetary system under the Uniform Commercial Code. Okay, it's all in the matrix, but it doesn't have to be. Again, do you know who you are? And you need to start thinking about these kinds of things and start doing things deliberately and calculatedly to free yourself. And it's really not that difficult. You just have to think about it a little bit. The reason you're paying taxes is because you're using a private money system. The way you avoid paying the tax is by not using a private money system. There's in Vegas, there was this company in Las Vegas that was paying their employees in gold or silver coins, and the IRS went and attacked them. And I don't believe it went to the Supreme Court, but they got acquitted is what happened, because again, there's nothing saying that you cannot pay in gold or silver coins, and it took them out of the matrix, and so they were acquitted. And so I don't know if they're still doing that or not, but yeah, it's very powerful, and it's when you buy something with gold or silver, you don't tell them you purchased something, you tell them that you converted gold or silver to this, okay? In other words, or the land, for example, okay? And I've even seen court cases that talk about it, okay? In other words, if I buy land, I've seen court cases that talk about it where they converted silver to land, okay? And conversion is common law, okay? That's a bill of exchange where you exchange something for value, something real, for something else that's real. And it's not a bill of sale. It's not a commercial transaction. And so you have to think about the words you're using, and you don't want them to think something that's not happening. And so it's not a bill of sale, it's a bill of exchange. And you convert gold or silver coin to land, or you convert gold or silver coin to this vehicle, okay, or whatever. And it's very important to be thinking about that stuff and making sure that that's how you do it. And if it's done properly, it's amazing just doing something as simple as that. Everything there, all of their power is an illusion. It's all an illusion. And once you understand that, they have no power. Quote, I believe the banking institutions are more dangerous to our liberties than standing armies. If the American people ever allow private banks to control the issue of their currency, first by inflation, then by deflation, the banks and corporations that will grow up around the banks will deprive the people of all property until their children wake up homeless on the continent their fathers conquered. The issuing power should be taken from the banks and restored to the people to whom it properly belongs, unquote. And that's Thomas Jefferson, the debate over the recharter of the bank bill. And Jefferson, you know, I really like Jefferson, quite frankly. You know, I've heard that he actually shot and killed a guy on the White House lawn for treason or something like that. I'm sure he had a good reason, but the point is that he knew who he was, and he didn't, you know, he was good people in my opinion. Anyways, quote, if all bank loans were paid, no one would have a bank deposit, and there would not be a dollar of currency or coin in circulation. This is a staggering thought. We are completely dependent on the commercial banks. Someone has to borrow every dollar we have in circulation, cash or credit. If the banks create ample synthetic money, we are prosperous. If not, we starve. We are absolutely without a permanent monetary system. When one gets a complete grasp upon the picture, the tragic absurdity of our hopeless position is almost incredible. But there it is. The banking problem is the most important subject intelligent persons can investigate and reflect upon. It is so important that our present civilization may collapse unless it is widely understood and their defects remedied very soon, unquote. And that's Robert H. Hemphill, credit manager of the Federal Reserve Bank of Atlanta for 8 years. So, I mean, who else would know? Quote, the enemy is the German Reich and not Nazism, and those who still haven't understood this and haven't understood anything, unquote. And that's Churchill's chief counselor, Robert Lord Vansittart, September 1940, to Foreign Minister Lord Halifax. See, the reason I'm bringing this up is that I have heard, and here's some quotes that talk about it, actually. We're going to go through some of them here. And that the reason that Germany was attacked in the Second World War was because they issued currency that wasn't borrowed from the bankster thieves. It had nothing to do with the fact they were dictatorial or tyrant. You know, look at history. I mean, they put up with dictatorial, tyrannical regimes all the time. And it had nothing to do with that. It had the fact that they were issuing currency. They weren't borrowing it from the bankster thieves. Quote, Germany's unforgivable crime before World War II was its attempt to loosen its economy out of the world trade system and to build up an independent exchange system from which the world finance couldn't profit anymore. We butchered the wrong pig, unquote. That's Churchill said that. Second World War, Bern, 1960. Quote, not the political doctrine of Hitler has hurled us into this war. The reason was the success of his increase in building a new economy. The roots of war were envy, greed, and fear, unquote. And that's Major General J.F.C. Fuller, historian, England. Quote, we made a monster, a devil out of Hitler. Therefore, we couldn't disavow it after the war. After all, we mobilized the masses against the devil himself. So we were forced to play our part in this diabolical scenario after the war. In no way we could have pointed out to our people that the war only was an economic preventative measure, unquote. And that's U.S. Foreign Minister James Baker in 1992. Quote, the war wasn't only about abolishing fascism, but to conquer sales markets. We could have, if we had intended so, prevented this war from breaking out without doing one shot. But we didn't want to, unquote. And that's Winston Churchill to Truman, March 1946. After World War I and the Treaty of Versailles, Germany was forced to repay the costs of the war and was bankrupt. Hitler's crime was that he did not borrow money from the bankster thieves, he printed it. And as a result, the German economy was turned around in less than 3 years. Kennedy circulated $6 billion of U.S. Treasury notes, and Johnson's first act while on a plane to D.C. after the Dallas assassination was to recall those notes. Lincoln was killed because he circulated U.S. Treasury notes. President Garfield was killed because he wanted to circulate U.S. Treasury notes. Under Gaddafi in Libya had debt-free currency, and they had him killed. Saddam Hussein was preparing to circulate a gold-backed debt-free currency until he was killed. Christ was killed 3 days after he threw the money changers out of the temple. The bankster thieves will stop at nothing to keep their power. There are two ways to conquer and enslave a nation. One is by the sword, the other is by debt, unquote, and that's John Adams, 1826. Quote, when justice becomes law, then resistance becomes duty, unquote, and that's Thomas Jefferson. And that's the end of the presentation on money. It certainly gives some food for thought. There's no doubt in my mind that that these bankster thieves are just flat-out criminals, and it all goes back to the Vatican. And the sooner we exterminate them off the face of the planet, the better. We need to, but part of that is to educate ourselves about what the real issues are, and understand what's happening and how it's happening. And until we can do that, not much is going to change. Now, I think what I'll do is I'll start on the land titles presentation. And we're all products of the government's educational system. The government has taught us what we need to know to operate in their system, but have they taught us everything? There's, from Black's Law Dictionary, 6th edition, talks about an absolute estate, which is a common law classification. An absolute estate is a full and complete state or an estate in lands not subject to be defeated on any condition. Allodial is free, not holden of any lord or superior, owned without obligation of vassalage or fealty, the opposite of feudal. An allodium is land held absolutely in one's own right, not of any lord or superior, land not subject to feudal duties and burdens, an estate held by absolute ownership without recognizing any superior to whom any duty is due on account thereof. Now, there's land titles, allodium. This is Black's Law Dictionary, or Bouvier's Law Dictionary, 1856 edition. Allodium, estate, signifies an absolute estate of inheritance in contradistinction to a feud, unquote. And that's, most of the land is held feudally these days. Certainly in Canada, in most places in the U.S., probably about 99% of the land is all feudal. But you can have absolute ownership, but it comes down to the money. Okay, you have to really pay for it. You have to be prepared to assert it. Okay, and every state has different laws, and so you have to learn whatever laws there are in the state to help you to assert it. But there are laws that are available in Texas. There's laws that I've used. And in Arizona, all I did is I brought up the fact that it was color of law and they had no authority, and that they were violating my rights under the color of law, the problem went away. If you register your land, you're essentially giving them the land, but you can record it. Recording it is common law. That's why they're called the county recorders in the U.S. You can record your land if you choose, and that is not a gift. And we need to train our bureaucrats is what we need to do. Real property is that which consists of land and all rights and profits arising from it and annexed to the land of a permanent immovable nature. In order to make one's interest in land real estate, it must be an interest not less than for the party's life, because a term of years, even for 1,000 years, perpetually renewable, is a mere personal estate. And that's taken from Bouvier's Law Dictionary, 1856 edition. And that's what essentially they've done, is they've converted real property into real estate. And when you buy a house and there's a mortgage on it, well, then it's real estate because you don't own it, okay? The bank owns it. You have an interest in it, and it's an equitable interest but the bank really owns it. You may have legal title, they have equitable title, and because the government's bankrupt, they're going to get it if you don't make those payments. Real property is land and everything that's attached to the land. Real estate is real property that you have an interest in, but you don't own it. Estate is the operative word. An estate is something you have an interest in, but you do not own. Like your father's estate. You have an interest in it, but you don't own it. Title, estates. A title is defined by Lord Coke to be the means whereby the owner of lands hath just possession of his property. And this is a definition of title to lands only. Now, title is either good or marketable or doubtful or bad. Okay, these are at common law. There's only 4 kinds of title. It's either good title, marketable title, doubtful title, or bad title. That's it. There's nothing else. A marketable title is one which a court of equity considers to be so clear that it will enforce its acceptance by a purchaser. Okay, so remember, we talked about equity a little bit. A court of equity will consider it to be clear enough that they will enforce its acceptance by a purchaser. Now, this is all taken from Bouvier's Law Dictionary, 1856 edition. The significance of that is that it doesn't have to be perfect, okay? And we'll talk about that a little bit more. Definition 7 under title estates is the doctrine of marketable titles is purely equitable and of modern origin. At law, every title not bad is marketable. Okay, so as long as it's not a bad title, it's a marketable title. And then definition 9 says, at common law, doubtful titles are unknown. There, every title must be either good or bad. So at common law, either it's a good title or a bad title. There's nothing in between. And definition number 10, a bad title is one which conveys no property to a purchaser of an estate. Okay? Now, I don't know, has anybody ever heard of the Brooklyn Bridge getting sold? Well, it has. It has actually on numerous occasions, and it's actually owned by the state of New York. And so, but what happens, okay, I don't know, has anybody ever seen a tax sale? Okay, when they sell land that's a tax sale, what happens is you get what's known as a quitclaim deed. And a quitclaim deed says that I transfer my interest in this property, in this land, whatever interest I have. I may not have any interest, but what interest I have, I sell. And that's how they always sell it. When it's a property, a tax sale, is they always sell it with a quitclaim deed. And so we'll go into that more as we get going further here. Anyways, definition number 11 says title to real estate is acquired by 2 methods, namely by descent and by purchase, and that's Bouvier's Law Dictionary, 1856 edition. In other words, when it's by descent, it's passed down in your family. Now, there's people that I know in Arizona that have passed their land on from generation to generation in their family. They just pass it on, and they've had it in their family for generations, and they've never paid property taxes, and it's not on the tax rolls. Okay, land titles come in various forms. There's a general warranty deed, there's a special warranty deed, a sheriff's deed, a judicial deed, a quitclaim deed, and a land patent. A general warranty deed is a deed where the seller warrants the title to be free of all liens and encumbrances. General warranty deed is generally what's received in order to get a mortgage before the bank will authorize the mortgage. General warranty deed is considered marketable title. Special warranty deed is a deed where the seller warrants the land to be free of all liens and encumbrances with some reservations. A special warranty deed is used when the land has been the subject of a foreclosure or tax sale. That's another thing. Okay, they usually do either a special warranty deed or a quitclaim deed. I've seen it done both ways. A special warranty deed is considered marketable title. Sheriff's deed is when the sheriff sells a piece of property. It could be a foreclosure or tax sale. Sheriff's deed is considered marketable title. Judicial deed. Judicial deed is when a judge orders the property sold, and it's also considered marketable title. Quitclaim deed. A quitclaim deed essentially says that the seller transfers his interest in a piece of real property, as property sold because of a tax sale can be transferred by a quitclaim deed. A quitclaim deed can transfer title as effectively as a general warranty deed, but a quitclaim deed may transfer nothing. And a good example is the Brooklyn Bridge. The Brooklyn Bridge, like we talked about, has been sold on numerous occasions, and it's always been by a quitclaim deed. And obviously, whoever sold it didn't have an interest to sell, and so, anyways, the burden is on the buyer to prove that you bought something. It's not on the seller to prove that he sold anything. And with land, that's how it works. Caveat emptor, buyer beware. But having said that, I told you about the people that we know in Arizona that pass the land on in their family from generation to generation. Well, they pass it on with a quitclaim deed. And so essentially what happens is the father will pass on his land to his son with a quitclaim deed, and he goes and lives there, and after 7 years he's essentially got it because of squatter rights anyways. Okay, it says, so an occupant is a good, an owner is a leasee or tenant. Correct me, please, I'm still learning the language. I don't know about occupant. I didn't say anything about occupant. I don't know where you're getting that from. Owner is a person, obviously. So I would try and stay away from owner, although if you own land, it's a little bit different. But certainly when it comes to motor vehicles and stuff like that, I'd stay away from owner. I'd say something like, I'm just the guy that's got it right now. But as far as depends on how you own it, okay? If you own it with, if you didn't pay with gold or silver coin, then you really don't own it. And you just think you own it. You only have an equitable interest, and you have you're a tenant is what you are, because you're paying annual rent. Okay, and that's the property taxes. The property taxes is an annual rent, and so if you're paying property taxes, then you're a tenant. But you can make it so that you do own it. Again, in Canada, you're going to have to train the bureaucrats, but really the best way to do it, in my opinion, is to get a First Nations title. That'll just trump everything. Anyways, so a quitclaim deed works just fine in some situations, and in other situations it's completely worthless. And this is Black's Law Dictionary, 6th edition, quote, a quitclaim deed, a deed of conveyance operating by way of release that is intended to pass any title, interest, or claim which the grantor may have in the premises, unquote. So that's what a quitclaim deed is I transfer my interest in this property. I may not have anything, but what I have, I transfer. Color, okay, remember we talked about color in the color of law. Well, there's such a thing as color of title, and I think I talked about that a little bit. And so color means an appearance, a semblance, a simulacrum, as distinguished from that which is real, a prima facie or apparent right, hence a deceptive appearance, a plausible assumed exterior, concealing a lack of reality, a disguise or a pretext. See also colorable, Black's Law Dictionary, 5th edition on page 240. Colorable means that which is in appearance only and not in reality what it purports to be, hence counterfeit, feigned, having the appearance of truth. Color of law means the appearance or substance without the semblance, without the substance of legal right. Misuse of power possessed by virtue of state law made possible only because the wrongdoer is clothed with authority of state is action taken under color of law. So, now, color of title, quote, these deeds include the ones as follows: warranty deed, quitclaim deed, sheriff's deed, trustee's deed, judicial deed, tax deed, will, or any other instrument that purportedly conveys the title. Each of these documents state that it conveys the ownership to the land. Each of these, however, is actually a color of title, unquote. And that's taken from G. Thompson, Title to Real Property, Preparation and Examination of Abstracts, Chapter 3, Section 73, page 93, in 1919. So all of these that we talked about are a color of title, okay? They look like title, act like title, but they're not title. And so what I think I'm going to do is I'm going to wrap it up here. And we'll do Lyme titles again to start off on Sunday. So remember, we'll be doing this same time, same place, same channel on Sunday night. And so for anybody that's interested, you can come and listen in on Sunday night. Or if you aren't available or whatever reason, you can still just download the file off of YouTube. Anyways, again, you're listening to Do You Know Who You Are? And this is Glenn Winningham, House of Fern, on These Changing Times radio station. My website is www.sovereigntyinternational.info. I have a group on These Changing Times website called sovereigntyinternational.info. I've also got a couple private groups at Yahoo and Google. They're called Administrating Your Public Servants. You can go there and request to join if you wish. I've also got a YouTube profile. It's called Sovereign Living. And I'm also available for private information shares for anybody that might be interested. So what I'll do, I guess, is I'll turn the time over to Kat. Are you there, Kat?
I certainly am, Glenn. So, as you heard, you've been listening to the Glenn Winningham Show. Do you know who you are? Please stay tuned for Ivana, Beyond the Looking Glass, at the top of the hour. Thank you all for listening, and soft parts. You've been listening to These Changing Times, times with a Z or a Z, depending on where in the world you come from, These Changing Times Radio.ning.com.